I'm Shanna O'Toole. I am the president and founder of the Due Process Institute. I want to welcome you and thank you so much for getting dressed and leaving your home offices to attend our 5th annual program, in which we ask two brilliant constitutional litigator scholars to help us explore key criminal cases from the Supreme Court's criminal law docket. This is truly a one-of-a-kind program. My vision in creating Due Process Institute was a simple one: to create a bipartisan policy shop to preserve procedural due process rights in the criminal legal system through any means necessary: legislation, litigation, public education. It's premised on the belief that regardless of political beliefs or partisanship, of which there is a lot in this town, there are fundamental principles at work in our criminal legal system that we can all agree on. And I happen to think that this program is a good example of that principle at work. Due Process Institute, we consider ourselves first and foremost lobbyists for the Constitution, and we employ lawyers and advocates from both sides of the aisle. I'd like to point out Jason Pye, our Director of Rule of Law Initiatives. There he is, waving in the back. He was one of the principal architects behind the passage of the First Step Act, so if that's helped any of your clients, you can thank him later. And right now, if you see him on his phone while this great event is happening, I can promise you that he is busy trying to engage Republicans in keeping funding for the Defender Services in the appropriations bill. They are facing as much as a 12% cut to their workforce right now if funding isn't restored, and Jason has been burning the midnight oil on Capitol Hill to try to prevent that. So thank you, Jason. But we aren't just lobbyists. We also pursue our criminal justice reform objectives through the creation of cutting-edge research and scholarship, and through the strategic filing of amicus briefs. And our sister organization, Clause 40 Foundation, pursues the same mission through its work. At Due Process Institute and Clause 40 Foundation, our mandate, our passion is to honor, preserve, and restore the principles of fairness in the criminal legal system, abolishing acquitted conduct sentencing, supporting the public defense functioning, bringing accountability to the prosecutorial function. Now, not 10 years from now. In the few short years in which we've been in operation, we have drafted, introduced, and passed meaningful criminal justice reform laws. We have filed dozens and dozens of amicus briefs, some of which have been on the winning side, and educated thousands of people on a variety of critical issues that need our national attention. Now here's the part of the story that's hard for me to say. COVID, and now its long aftermath, has hit us hard, organizationally speaking. As a fairly new organization, not being able to travel to meet new people, to share our ideas, to create new partnerships with funders, or to hold super large, successful fundraising events, it's had an impact on our budget, a severe impact. We are incredibly grateful to the law firms that generously partnered with us to help sponsor this event, but unfortunately that support does not go far enough to cover its cost. This event we continue to put on for free every year so that anyone who wants a seat gets one. We also desperately need more funding to expand our staff. Just ask Tamara, who you met while coming in the door, who has at least 4 job titles, or Trey Brown, who's here doing our AV today, but who wears 4 different hats when we get back to the office. I'd like to ask each of you, if you get value from this program, from the work that we do, if you support our work that we're doing in the Congress or in the courts, please take the time now to support our work, because every dollar truly does help. We have tried to make it easy for you. There are cards on your seat when you came in. They're QR cards that will take you directly to where you can make a tax-free donation to Clause 40 Foundation. That's the gray card. Or if you would like to support our lobbying efforts, you can make a non-tax deductible contribution to Due Process Institute. Those are the orange cards. Both efforts need your support. New this year, you can get this super cool t-shirt that I'm wearing under my suit for your $75 or more contribution to Clause 40. So you want a t-shirt? Snap this QR code, pay, take a screenshot of the receipt, see Tamara on the way out the door, and she'll give you your t-shirt. If you don't like QR codes, just visit our donation pages on our websites, or you can hand me cash on your way out the door. I'd happily accept it. And please know, money is not the only way you can support our work. We have a room full of lawyers here. We have amicus requests pouring in from across the country. Sadly, we have to turn down many good ones. I've got this super exciting white-collar obstruction of justice one sitting on my desk right now that I don't have an author for. So while we wait for your donations to pour in so we can hire more lawyers, if you or your law firm would like to be a part of our amicus efforts, we would love to have you join us. Please sign up with Tamara on the way out the door and let her know, or contact me, shanna@idoprocess.org, and we will get you involved working on the issues that you care about the most. And now just a few housekeeping notes. In order to receive CLE credit for this program, you must have checked in at the registration desk with Tamara today because we have to certify that you showed up. So if you didn't do that, check with her on the way out. Also, folks wanting specifically New York credits need to sign out with Tamara. I'm guessing you guys already know that. You've been through that drill. And now pay attention to this part. For CLE folks, once we get our approval, we will be emailing you the CLE certificate. So if you gave us a mostly fake, abandoned email address to register for this event, and given the laughter, we know who you are. We know. If you did that, that's the email we have for you, and we'll be mailing your CLE certificate to that email address. And then months later, you'll be panicked when you need to prove, and you'll reach out to us and say, I never got it. So do us a favor. Could you please give us a real email address on your way out the door, Tamara, for CLE purposes? I promise you, we will not spam you. I promise you. All right. We're now going to give you maybe 10 minutes to speed through your salads, get your mains in front of you, and then our program will get underway. Thank you so much for being here with us today. Thank you so much to our sponsors who are here to help us put on this event. Shout out to Barry Boss and his colleagues at Cozen O'Connor who are right here. Shout out to Blair Brown and Zuckerman Spader. Shout out to Andy Wise and Tim O'Toole and Kate Atkinson over there from Miller and Chevalier. Shout out to Bill Petard from Kaiser Dillon. Please help me thank them right now. All right, enjoy your lunch and prepare to have your minds blown by Jeff and Erin.
Thanks, Shanna. People who have been here before have heard Erin Murphy talk, and you probably have heard her talk other places, and you know she's a rock star, and you don't need me to tell her or tell you, but I'm supposed to do an introduction, so I'll do that. She went to a fancy college. She went to a fancy law school. She seemed to do well at those places because then she had fancy appellate clerkships. She clerked on the Supreme Court for Chief Justice Roberts. She went on to do fancy appellate law at fancy DC firms. None more so than her current firm of Clement and Murphy. She's argued and briefed countless cases in the federal courts of appeals and countless cases in the Supreme Court. Well, I bet those are counted actually. And then the one thing I would say, in addition to those things, which is of course all you need on her cred, but is that I was a bureaucrat at the House of Representatives for a while. And we hired Erin Murphy and her firm to help us on a couple of things. And so I had the chance to sort of personally see her work and be really impressed by it. And not only was it really good, as you would expect, but the kind of things that we were working on tended to be highly politicized because it's the House of Representatives, whether it's on social issues or just the political issues of the day. And not only was she really good, but she did it without sort of any commentary on her own political beliefs one way or the other. She was, what I think is really the sort of the ultimate compliment in our profession, which is she's a lawyer's lawyer. So that's something that I appreciated then and continue to appreciate about her. So, Sarah.
Hey folks, so I get the the distinct pleasure of introducing Jeff Fisher. Jeff is the director of the Supreme Court Litigation Clinic at Stanford Law School. He has argued close to 50 cases in the Supreme Court over the last 20 years, including some of the most important and impactful criminal cases that the court has heard during that time. Jeff has argued and won cases that gave life to the Confrontation Clause, that altered the impact of the guidelines on federal sentencing, that applied the Fourth Amendment protections to the modern digital era and preserved the unanimous jury requirement in serious criminal cases. He's also been involved in a number of important cases outside of the criminal context. He was co-counsel for the plaintiffs in Obergefell, the case that guaranteed same-sex couples the right to marry. Jeff was destined for greatness after being part of the University of Michigan Law School stellar 1997 class. He then clerked for Judge Reinhardt on the Ninth Circuit and Justice Stevens on the Supreme Court. He has before, and I'm sure will continue, to change American life for the better by being the voice in the highest court and the advocate for people who otherwise might not have had their say. So it is my great pleasure to introduce Jeff and welcome you all to this session.
Well, thank you all for being here. It's a pleasure to be back. I actually don't know how many years we've been doing this now, but several. Fifth, okay, 5. There you go. We've got a lot, we have, well, maybe a little less than some years to talk about, since the court has a lot fewer cases generally this year than they have in recent years, and not, the most robust criminal docket ever, but we got plenty to talk about and some cases to talk about from last term and this term as well. But we thought we'd kick things off with just, a few kind of overview insights, thoughts about last term and where this court is, not just in terms of due process and criminal issues, but more generally. And I'm happy to kick off with a few thoughts of my own,
please.
If you want to then jump in. I mean, I think one of the interesting dynamics when you do previews around now and you're thinking about what the themes are that we took from last term, what the themes are from next term, it's natural to think back a year ago and think, what were people saying last year? Were the themes, what were we thinking we knew about this court or didn't know about this court? And a year ago now, in my own experience on most panels I was on, two common themes were, look, we have a 6-3 court, and not just a 6-3 conservative court, but a 6-3 conservative court with a pretty aggressive conservative majority that is, not afraid to move the law as quickly as they want to, wherever they want to, and seems really open to, aggressive litigation, overruling cases, whatever it may be. And I think another common narrative, very related, was, and the Chief Justice has kind of lost, any real power and persuasion in this court, given that dynamic and given where we are. Whatever we know about the court at this point, I think it's fair to say, neither of those things proved true over the past term. We did not see, we saw a court that not only, did not have a lot of, certainly there were conservative decisions last year, don't get me wrong, there were several big cases that did come out 6-3. There were also several big cases that did not come out 6-3 conservative, or that even came out 6-3 in kind of the opposite direction of what people may have been predicting a year ago. And the court, despite having, they had 5 or 6 cases where they were asked to overrule precedent, and in pretty stark comparison to the previous term, there's not a single case in which they explicitly did. You could debate whether there's a case or two where they, implicitly did, but even that is a little counter to the narrative of they don't really care and are no longer kind of concerned about thinking about things through an institutional lens. So I do think, the of course big question is which one is the real court? Is this a reaction to what the court had done the previous term in Dobbs, and or is this really, Dobbs was sort of the anomaly term, and this is a little bit more the court we can expect to see in the future with really, 3 justices kind of in the middle in some respects and not always aligned with each other, but the Chief Justice and Justice Kavanaugh and Justice Barrett kind of being in the majority in most cases, whether or not whichever direction they'd come out. And the other piece of it too, and I will say for the record as a chief clerk, I never accepted the narrative that the Chief Justice had gone by the wayside, because he never does. But lo and behold, of what I think of as probably the 5 biggest cases, he wrote 4 of them. He wrote 2 of them that were 6-3 conservative. He wrote 2 of them that were more surprise cases that came out the other way, holding together different majorities of the court. So you really can't kind of look at it as, oh, he went along a particular way to keep the opinion. I mean, he's keeping people with him and keeping the court in many respects. Even if you take something like the affirmative action case, which of course is definitely a change in the law, but I think a different justice may have written it differently. Instead, you have an opinion written by the Chief Justice that nowhere says we're overruling anything, that makes an effort to make this all seem like it's coming naturally from the where the court's been all along. And so this kind of incrementalism, a little bit more institutionalism, does not seem to be dead to me on this court at this point.
That's a great point. And before I say anything more, just thanks so much for having me to this event. It is, I guess I know now, the 5th annual, but it's something I look forward to every year, just to see old friends like Andy and so many of you in the audience, and just it's a pleasure to be here. So thanks for coming and supporting DPI, which is such a great organization. So I think Erin's comments they strike a lot of chords with me. And it's funny, I think there's a famous quip by Justice White that says, every time we get a new justice, it's a new court. You might think, oh, it's just one new person, but it changes the whole dynamics. And it's almost like I'm tempted to take that to the next step, which is like every term is its own new court, right? So the Dobbs term really did seem so different than last term. And maybe a good example of that is, if we want to talk about a substantive theme, is race. I mean, race was a big subject of last year's term on the affirmative action cases and admissions, college admissions, and also the Milligan Voting Rights Act case from Alabama. In the affirmative action cases, the court obviously cut back a great deal on the ability of universities to use race as a factor in admissions, but also left some possible room for other avenues to achieve diversity, and the remains to be seen, I guess, as it shakes out on the ground, but maybe some moderation there at the tail end of the opinion at least. And then the Alabama case may be the bigger surprise, where all indications were that the conservative majority really was quite hostile to the Voting Rights Act and its requirement to take race into account in drawing voting districts, and having granted a case itself, or at a previous stage of affairs, the court had strongly signals it was going to take an aggressive, I don't mean to use that word, but carve back on the Voting Rights Act protections, and then it didn't, and so that was quite fascinating. And when you sit in a room of criminal lawyers, race is always one of the big issues that permeates your work, and so the court's attitude toward race last term, as it might bleed into other areas, I think is really something to watch, whether that was a one-term phenomenon or whether that's something of an attitude that's going to carry over to criminal law in various ways. The other thing I'll just say by way of overall themes, picking up on Erin's other quick comment about the court's thin docket, and we're going to remark about that a couple of times today. It's not just on the criminal cases. Overall, the court's hearing fewer cases. So maybe it's bigger but fewer in some ways, but maybe even this term not necessarily bigger. But the court is hearing fewer cases and fewer criminal cases for sure, at least in the big ones. And maybe we'll talk about various reasons why that is so. But one thing I think I'll mention right now that I find to be a little bit distressing, and I think I might have mentioned it last year, and I wrote a little piece on it this summer, is that the 6-3 court, I think, we focus so much on the outcomes in merits cases, and maybe not as much as we should on what cases the court puts on its docket in the first place. And the rule inside the court is you need 4 votes to grant cert. So 6-3 majority can really shift the dynamics from a 5-4 majority when it comes to whether a case gets put on the docket. And one thing from the criminal law perspective that I worry about a little bit, from the criminal defense perspective that I worry about a little bit, is that the court over the years had granted, 2 or 3 cases a year that I might have thought of as error correction cases where there's a real injustice done in a capital case or some other kind of criminal prosecution. And the court just said, hey, it's our institutional duty to make sure things don't go too far off the rails, particularly if it's a big high profile, a big case, not necessarily high profile, but a big sentence. And this term, by contrast, the court denied cert in 2 such cases. One from Mississippi involving the Batson right against racial discrimination in choosing juries. Another case from Louisiana that I was involved in involving the Brady right to have the prosecution turned over favorable evidence, where the 3 Democratic appointees wrote in dissent from denial of cert saying these are exactly the kind of cases we've taken in the past on occasion to keep the rails of justice in line. And so that's something I'm going to be watching, is to see whether it's a little subcategory of cases on the court's docket, but I think that have been important over the years in the court's institutional signal sending, that maybe one of the shifts in the 6-3 dynamic.
Yeah.
And maybe just now like a lot of circuit split cases that need to be solved, which are important in their own right, but not the only thing maybe the court should be doing.
Yeah, I do think they also have a little more interest. I mean, this isn't uncommon. The court has always done this, but definitely a little more interested in the white-collar side, where they seem happy to reach out even if they're not necessarily circuit split cases. And some of that is a question of how much you get in the cert grant process out of the sort of little bit of libertarian streak among some of the 6. So I think on some of these issues, they're not necessarily completely aligned, but we'll see how it plays out.
Yeah. We're going to talk about a couple of cases from last term and then scoot into this term. So maybe that's a good segue.
There you go. Yes.
To this term.
Yes. So I'm going to kick it off with a couple of the big white collar cases from last term, or at least the white collar cases from last term. They both ended up in a little bit of a funny way that it's unclear that they held all that much when all was said and done. So the court resolved both the Simonelli case and the Percoco case last year, which were both cases arising out of the Second Circuit, and both in the white collar context, and really both even involving like some of the same players in some New York corruption scandals. And both actually ended up being cases where the court like resoundingly rejected what the Second Circuit had said, but then like didn't say a whole lot more than that, or give a whole lot of guidance about what the right answer was beyond, well, the Second Circuit had it wrong. So the Simonelli case was the case about the so-called right to control theory of fraud under the federal criminal fraud statutes. Mail fraud and wire fraud and bank fraud kind of came into play a little bit throughout the course of the court's discussion. And the theory, generally the court has said for the fraud the fraud statutes that you need to have deprive somebody of a property interest. And so the court's had cases over the years about what isn't a property interest, and it's pretty much scaled back and said, like, look, a property interest means a property interest. We want a pretty traditional property interest that you need to have taken or tried to take by virtue of the fraud. The theory of the right to control theory, this was a theory that largely just kind of existed in the Second Circuit. And the theory of it was that the property interest that's being taken is valuable economic information that somebody would want to know for purposes of deciding what to do with their property. So the case involved, basically it was the county or whatever it was had hired an outside nonprofit to run a process for a government bidding for government contracts. And the allegation was that Mr. Simonelli and his organization had basically kind of paid them off to get the process crafted in a manner that would make it easy for them to win the bid. And they did win the bid and won the work. And the government then proceeded with the prosecution, not on the theory that the property was, getting the government contract, but on the theory that the property fraud was depriving the state actor of the information they would have wanted to know that the process had been rigged in a manner that would make it easier for them to get the work. It's a little bit odd, and you kind of ask yourself, and this kind of came up a lot during the argument, like why exactly you go with this sort of seemingly more strained theory. I don't know if they just didn't really think they could actually prove up that they wouldn't have gotten the bid anyway, but that the government, did not try to prove that up and instead went on this right to control theory. By the time the case got to the court, even the government was essentially agreeing that the right to control theory is not really right, at least as it had been articulated by the Second Circuit. There was a great moment at argument where Justice Gorsuch said something to the effect of like, we're all in violent agreement, that the right to control theory is wrong. Like, so what do we do now? And a lot of the briefing and a lot of the argument turned on the government basically saying, look, you should still be able to affirm this conviction on other grounds, or at least we should be able to kind of try most of these cases anyway as traditional fraud cases, because you're going to be able to prove that there wasn't just the loss of the information, but there was also the loss of the property. The court ended up unanimously rejecting the right to control theory, but they didn't go any further. They rejected the government's argument to have the Supreme Court step in and decide in the first instance, whether this had been harmless, whether there was an alternative theory. And so they really didn't address the questions about whether you can actually still kind of try most of the cases that have been tried historically under the right to control theory, whether you could still get there via some more traditional property fraud theory. And Justice Alito actually wrote separately to lay out all the things that the court was not answering and make very clear that he thought it was open to the government on remand to go back and argue alternative theories or even potentially retry. So another case in kind of the line of the court rejecting broad conceptions of the fraud statutes, but one that ultimately didn't do a whole lot to, I think probably do anything more than knock out a couple of pretty aggressive theories that were being pushed up in the Second Circuit. You have a little bit of a similar dynamic in the Percoco case. So this case involved, it's an honest services fraud case, but the defendant, while he had been in the governor's office at various times, very close with the governor, at various times of the allegations at issue in the case, was not working for the government. And so the question was basically whether or under what circumstances a private citizen can owe a duty of honest services to the government by virtue of having some sort of sufficiently close relationship or being sufficiently closely connected to the work that is happening in whatever government office it is. And this, too, was basically the product of kind of an older Second Circuit case that had adopted a pretty loose standard for holding private individuals to have an honest services duty and be able to be convicted under honest services fraud theory. And so the case ended up being largely about the jury instructions that were given. And the way the court had instructed here was that they said that you could extend this to Mr. Percoco even at times when he wasn't serving as a public official, if the government proved first that he dominated and controlled a government business, and second, that people working in the government actually relied on him because of a special relationship he had with the government. And what the court ended up saying was that instruction is way too broad. It's basically unconstitutionally vague as a theory because the average citizen is not going to be able to figure out when they are and are not charged with the honest services duty, as the court noted, and a lot of the argument in the case said. I mean, if you take that standard for all it's worth, like any really good lobbyist would suddenly owe a duty of honest services, which is sort of contrary to the whole idea of being a lobbyist, where you're supposed to actually be trying to help your client, So it was a way overbroad theory. The government here too, didn't really kind of defend exactly what had been charged below. It instead said it advanced its own alternative theories as to when you should be able to have private citizens have the duty. The court agreed with the government and rejected the defendant's argument that that private parties never have a duty. And the court said, look, there could be circumstances when a private party does. And the government posited that the circumstances should be either when the person has been selected to work for the government in the future, or when the person exercises the functions of a government position with the acquiescence of relevant government personnel. And as to those, the court rejected the second one and said, look, it's basically just a restatement of the same thing that we just said was impermissible that the Second Circuit had held, because it's really just saying, like, well, sometimes you owe a duty and sometimes you don't, and we can't quite tell exactly when it will be. As to the first theory, the court didn't address whether it was a viable theory, because it just said the government never tried to prove that he was going into future government service. And then that was just the end of the opinion. You're kind of reading along, waiting, thinking like, and now maybe they'll tell us what are the circumstances and what is the test for when a private person can have a duty of honest services, but they didn't. They instead basically said, well, it's not what the Second Circuit said, and it's not what the government said, and we'll leave it for another day, exactly what it is. It was a unanimous opinion, a decision from the court, judgment line-wise, that there was a concurring opinion from Justice Gorsuch and Justice Thomas, once again articulating the view of all of this honest services fraud business is itself just unconstitutionally vague, and we should get out of the business of trying to fix a mess that Congress made. But that was just a concurrence, so it's unclear that everybody's really willing to go that far at this point.
Yeah. To my mind, I see these cases as a subset of a broader trend at the court, really for a decade, maybe two, of just increasing skepticism of broad readings of loosely worded federal criminal statutes. And the mail-in wire fraud cases, I think, are probably the core of that. But then there's a variety of others. And in one case I'm going to mention real quick last term is another example of kind of this theory, I think, which is also, I think you could frame it in terms of the court's skepticism or increasing lack of patience with prosecutorial discretion as it's exercised, at least in some pockets of the country and some offices. And so the case I want to mention is called Dubin against the United States, decided last term. This is one that I handled. It's another unanimous decision. I think it's interesting that we're talking about starting out talking about unanimous decisions in these substantive criminal law cases, dealing with maybe the broader theory of overcriminalization or the concern of overcriminalization. So Dubin is about the aggravated identity theft statute that makes it a crime, and I'll just read you the text of the statute, to knowingly use the means of identification of another person without lawful authority during and in relation to a felony, and usually it's a fraud, but some other kind of, but some enumerated felony. So we all have an instinctual idea what identity theft is. Probably, if you're like me, you got a call one day that you found out your credit card was used to buy an amazing new flat screen TV for somebody who you never heard of, and you had to cancel your credit card, and that was a pain in the butt. And but if you read these words carefully and literally, it just says use somebody's name during in relation to a felony. And so what the government had been arguing across the country was that, yes, of course, it covers traditional, what we think of as core identity theft, but it also covers any use of somebody's name while you're committing a fraud. So I represented a guy named David Dubin who was charged and convicted of healthcare fraud for essentially overbilling. On the count that's relevant to the case, he was convicted of billing $500 for a psychological services interview that under the Medicare rules should have been charged at about $380 because of the credentials of the person doing the interview. So he was tried and convicted on that count of healthcare fraud, but the government said you also have a mandatory 2-year prison sentence you need to serve for aggravated identity theft, because after all, when you submitted that bill to the government, a person's name was on it. The patient's name was on it. So you use that person's name during in relation to your healthcare fraud. And the Fifth Circuit accepted that theory, and there was essentially a circuit split on the issue, and the court granted cert to resolve it. And as I said, the court decided ultimately 9-0 that the government's theory was too broad, and that the name used in the fraud has to have a much tighter connection to the actual fraud itself. So it has to be a lie about the name and a use of the name without permission, essentially. And two comments about Dubin that I think I want to make, and one kind of is going to turn me to a question maybe to Erin. I'm curious on her views. But one thing is, this is a case where I think we got a lot of mileage at the court. I don't think what I'm saying is that scary. We can continue? Okay. All right. I'm being told that it's okay for us to continue and that it's a false alarm. Okay, this is like interesting practice. Yeah. Yeah. I'll do my best to enunciate over the noise, which will hopefully end. But the thing that I think resonated with the court in the Dubin case is a path that I think other cases have taken in this regard, which is what I think of when I'm the lawyer is, if the government's rule is right, then let's imagine all the other things that could be prosecuted under that theory. And so, for example, for the people in this room, one of our examples was a lawyer who overbills a client by a tenth of an hour would be guilty of aggravated identity theft because they would be using that person's name in conjunction with a wire fraud. We used the example of a waiter, staying with the sort of setting in this room, of bringing the wrong meal and intentionally charging for the higher priced order and the like. And the court, the government is quick to respond in these cases. Oh, we would never charge that. But the interesting thing in the Supreme Court has become that is not an answer anymore. And it goes back to the court's skepticism of prosecutorial power. And I think the court sees, even in a case like Dubin, that the aggravated identity theft charge is really being used as a cudgel quite often to try to force people into plea bargaining to the underlying fraud. And when somebody dares to go to trial on the underlying fraud, and by the way, David Dubin was acquitted of 26 of the 27 counts of underlying fraud, he pays the penalty of getting the 2-year sentence. And I think that underlying dynamic might have been really troubling the court. So it's come up with things that the government's rule would lead to, and then if the government doesn't have a good answer for that, the government seems to be in trouble in the court. And the other thing that I want to pull out of the Dubin case and name is the court's interesting approach in terms of statutory interpretation in these substantive criminal law cases. So when I say to you what's happened over the course of several years is that the court seems to again and again read broadly worded criminal statutes somewhat narrowly to focus in on, its core purpose or maybe its core meaning, and not give a broad literalistic interpretation of criminal law. You'd say, well, of course, that's the rule of lenity. But at the same time the court's been doing all this, it says we're not applying the rule of lenity, and Justice Kavanaugh has come out especially forcefully to say, I'm not interested in ever applying the rule of lenity. But when a criminal statute has a very broad reach, we should nevertheless read it narrowly. And so I don't know if, I don't mean to put you on the spot. I don't know if Erin, but with the court's real, firm commitment to textualism and its apparent renunciation of the rule of lenity, it seems odd that it seems to me to be effectively applying a little bit of a different rule in the criminal law space, but not naming it. And I don't know if you have from anything you've handled, any theory on that.
Yeah, no, it's really interesting, and I think, some of it gets into, there was some really interesting back and forth in a few different cases last term about the major questions doctrine and how to think about that, and I think a lot of it's a response, it's some of the justices taking seriously and responding to the critique that some of these canons and interpretive principles seem at odds with textualism, and that's been one of the critiques about the major questions doctrine as well.
Yeah.
And so some of them care more than others about that, and I think have worked to kind of figure out how do we situate these things as actual just interpretive principles that don't seem like kind of random substantive thumbs on the scale. But one of the things that seems to be going on, is the court getting a little more robust with its conception of vagueness, and it ends up, if you just sort of do that and you end up saying like it's pretty easy to show that a criminal statute's unconstitutionally vague, it's a little bit like you've just substituted a constitutional principle for the rule of lenity in terms of having a bit of a heightened, there is a clear heightened vagueness standard in the First Amendment context, and it's almost like the court, without quite saying it, seems to be, and then some of them have said it a little bit more, but having a little bit of a heightened vagueness, which makes, comes from the same position of thinking it's less a, we're going to assume Congress didn't mean to do this, and more a, well, if you want to take away somebody's liberty, just like if you want to take away their First Amendment rights, you should have to speak with a special clarity. And, and I think some of them who care more about being particularly doctrinal about things may find that actually a little bit more comfortable way to get to the same place, or to think about it, from. That's interesting. So.
Oh boy.
Turn it on.
So that's interesting. It's almost like constitutional avoidance as a way of thinking about it. Yeah, I like that.
I do think a lot of them have the instinct of reading substantive criminal law narrowly.
Yeah.
Where they all are on procedural law, a little bit different.
Yeah.
But
relatedly, one other thing I wanted to mention, two things, I guess, related on they're a little more procedural, but it gets us out of the pure substantive criminal law, at least, is actually Dubin itself has an interesting postscript about to play out, where on remand, even though the Supreme Court wrote a 9-0 opinion saying David Dubin did not commit aggravated identity theft, he's innocent of that crime, on remand, the government in Texas is arguing he should nevertheless have his conviction affirmed and be required to go to prison for 2 years because he didn't move for acquittal in a proper way in the district court, and so he fails to satisfy the plain error doctrine. So we'll see how that plays out on remand. And relatedly, the court decided another case last term called Jones versus Hendricks, which dealt with what to do when the court does narrow up substantive criminal law, not just for the people on direct review, but for people on habeas. And if you're on your first habeas, I think you're probably fine. But the question is, what happens if you've gone through your first habeas and now you have to come in and basically, you could just say, hey, I'm innocent. Now that the court has read the statute the way that I, more narrowly than it was read at the time of my trial or my plea, I'm actually innocent of the crime. But the way that the statute is written, and some of you I know do habeas work and know what a labyrinth it is, but essentially to bring a successive habeas petition, you either have to have a new rule of constitutional law, which you don't have here because it's just a statutory decision that narrows things up, or you have to have factual innocence, not legal innocence, which you don't necessarily have here either. And so the court held in the Jones case 6-3, I think it was, that you're not allowed to bring a habeas petition when the court has a successive habeas petition when the court has narrowed up the scope of the statute under which you were convicted. So you had this dichotomy between substantive criminal law on direct review and substantive criminal law as it plays out on the habeas realm. And maybe that just ascribes to the court's difference in perspective on habeas versus direct review. But certainly I think it's fair to say the court did accept a sort of broad literalistic reading to bar the habeas petition in this case. And so it's an interesting dichotomy. So the court, this much, but not so much more. Yeah, I don't know.
Yeah.
Well, do you want to switch over to this term?
Sure. Are we starting with Rahimi?
Yeah.
Okay. Well, I'll start with...
Or do you want to do our any general stuff
first?
Sure.
Or, I mean,
general ideas? Or
where are the
features
cases?
Yeah. What
Yeah, I mean, I do think that's one of the big themes of this.
Yeah.
term
So
at
why don't
this
we say a
point.
couple of things about general, and then we'll do
Yeah.
a few cases.
Yeah, sure. Yeah. No, I mean, really, I think at this point they may have like a historic low number of cases that are scheduled, and they're doing kind of one a day in the fall, in even through November, and they seem. I think it's fair to say at this point, at least, there's not like blockbusters of the dimensions we've had, not even just over the past 2 terms, but over most terms in recent years. Obviously, there's plenty of time still to come, so we'll see. They could easily end up with a lot more before the term's over. But right now, there's some really interesting cases, but not things that are quite of the magnitude, or at least that kind of are going to grab public interest in quite the same way. The court does have a particularly robust set of interesting administrative law cases lined up for this term. Obviously, they have the case about overruling Chevron, but also a really interesting case about essentially whether there are any limitations on the appropriations clause. The Jarchese case has like a whole host of interesting issues about one being a 7th Amendment jury trial issue, but also kind of non-delegation issues. There's just a lot going on there, which I think is consistent with this court for a long time, even without its most recent changes in membership, having kind of a deep skepticism of the administrative state, a general skepticism of exertions of executive power, especially when you have agencies seeming to be a little out of their lane. We saw, one of the big cases of last term being the student loans case. And so, but I think the real question will be, it sure looks, for those who haven't followed the Chevron case, one of the interesting dynamics about it is that the court has denied any number of petitions about overruling Chevron. And lo and behold,
I've seen your name on it.
we were expecting another denial, but lo and behold, now we've got one, and they took it up. And the case, as is common in cases where you're asking the court to overrule Chevron, had 2 questions presented in the petition. One being, did the D.C. Circuit get the question of statutory interpretation wrong? And the D.C. Circuit applied Chevron deference, and so are they just wrong about the statute? And 2, to the extent you think it is ambiguous and should go to Chevron, should you overrule Chevron? And the court granted cert only on the second question of whether to overrule Chevron. So it sure seems like they are serious this time around about actually confronting the question and really doing some stuff this term with administrative law. So at least for now, that looks like that's going to be one of the big themes of this term.
Well, I will mention 2 quick themes. One criminal, one non-criminal. The docket, as you're about to hear, is very thin right now on the criminal side for this coming term. So I don't have a grand theme to give you on that front. But another little thing I'm just watching is that the Jones case I mentioned just a minute ago, the habeas case, was the second case during the Biden administration where the Supreme Court has ruled against criminal defendants in cases where the government agreed with the criminal defendant. A case called Terry involving the First Step Act was the first, and then Jones was the second. And there are 2 more cases heading up to the court, either this term or next, depending on how the timing plays out, where the government agrees. One's a First Step Act case, and one's an Armed Career Criminal Act case with the defendant. But the Court of Appeals said no. The defendant still has to serve the longer sentence and cannot get relief. And so it'll be interesting to see if the court again takes a skeptical eye in these new cases towards situations where the government itself is saying, we don't want this person in prison this long. We don't think he should be there. In one of those 2 cases, the Sixth Circuit, in the denial of embank, in a statement by a few judges, said, look, Congress has tied our hands. If we could make this decision for ourselves, we'd agree with the government and the defense, but we don't have that power. And so it's like a little bit like through the looking glass. It's like, you're the only thing standing in the way of relief. You do realize that, right? But we'll see how the Supreme Court reacts in those cases. And then the other, I think, big picture item to watch out for this coming term is the court's interaction with social media or big tech. The court kind of dipped his toes in the water last term in a case involving what's known as Section 230 of the Communications Decency Act, and granted cert on the question whether tech companies should be immune from lawsuits in cases where harmful content is posted on their platforms. But the court basically sidestepped that question by just saying the cause of action in those cases was defective in the first place. But this term, the court has really 3 cases, and 2 of them are 3 clusters, 3 issues, I guess I would say, either on its docket or likely to land on its docket, involving content regulation and moderation on social media and public officials' use of private accounts to engage with their constituents. And so a mixture of state action and First Amendment questions in cases that are going to land on the court's docket. One of which you've probably been reading about, that's up on emergency stay application right now, with the Fifth Circuit's ruling that the Biden administration transformed the tech companies into state actors during the COVID era, and would continue to do today by interacting with them, and as the Biden administration puts it, persuading them to take down certain content, and as the plaintiffs in the case argue, coercing them to take down certain content on their sites, turn them into state actors in violation of the First Amendment. Cases from Florida and Texas, and Erin may want to say a word about, because she's involved, involving state laws that tell the platforms that what they're allowed to post, and to some degree, and require certain disclosures and explanations along with what content ends up on their platforms. Really big, important questions for our culture, for our democracy, and ideologically freighted, potentially. And so we'll see how the court reacts to all of this. And it could be a very momentous year if the court really does bite down hard on all these issues.
Yeah, no, the 2 net choice cases, those are the social media, Florida and Texas law cases, to your point, they too end up being a little bit of a debate about state action, because certainly, especially in Texas, the lead argument the states are making is we can do this and we can moderate your content because you're effectively common carriers, and so you don't have the rights that you might otherwise have. And so, that's obviously we vehemently disagree with that. My clients do, and believe they're private actors who can make their own decisions about what's on their sites or not. But that's a big piece of the whole argument. So a lot of it becomes a debate about, and a little bit of a debate we saw even last year in the 303 creative case about kind of whose speech is it,
Yep.
And if you are providing a platform for speech, how much of your own speech is part of that. That's really at the core of those cases. So, and their case is part of the reason we're saying they seem likely to be granted is every party in the cases on both sides, and now the United States through a CVSG, have all told the court to grant cert, at least on the core questions in the case. So maybe they don't care what anyone has to say, but everybody seems to think that the court should grant these cases. So those will be up at the long conference in just a week or so, I guess it is at this point.
Right. And probably the other biggest case on the court's docket right now is Rahimi, the Second Amendment case. So I think, Erin, you want to start with that, and we can go back and forth on a couple of others.
Yeah, absolutely. So I'm sure you all recall a couple terms ago the court decided the Bruin case, where it not only resolved a substantive Second Amendment question about whether you can carry a firearm, a handgun outside the home for self-defense, but also had this kind of revolutionary discussion of how to analyze Second Amendment claims. And the court said, in this context at least, we're not going to import levels of scrutiny. We're done with all that. There is no place for kind of means and scrutiny and interest balancing here. We're instead going to have a test that's based entirely on text and historical tradition. And so what the court articulated in this context is a test under which you start by asking whether the conduct in which an individual wants to engage appears to be protected by the language, the text of the Second Amendment, and if it is, then it's presumptively protected, and the burden shifts to the government to prove that however it's restricting that conduct is consistent with the way that that firearms have been regulated historically in this country. And so that's sort of the basic framework we have. Bruin is only, a little over a year old, and I can't tell you how many cases I've already litigated about how this framework works. I'd love to get your thought. One of the constant refrains in this area is like history. We can't be historians. We can't do history. Now, of course, you argued one of the famous cases where nobody seemed to have a problem doing history when it came to, Crawford and some other criminal contexts. But all of a sudden, it's like,
I was doing history tradition before it was cool.
I know, and now all of a sudden we're all told we're incompetent and you can't read history unless you have a history degree. But so there's a lot of really interesting litigation going on, both civil and criminal, about how, what does this mean? How do you do this? Well, the court will have its first opportunity post-Bruin to weigh in on that in the Rahimi case this term. This is a criminal case. It arises out of a prosecution under the federal the long list of federal prohibitions on who may possess firearms. This case concerns the prohibition on possessing a firearm for people who are under a civil domestic restraining order. And so the individual here has a lot of various criminal history, but what triggers this particular prosecution is he was subject to a domestic restraining order at the time that he was found to be in possession of firearms, and the case went to the Fifth Circuit, and the Fifth Circuit, doing this historical tradition test, concluded that it did not think the government had met its burden of proving that this is a restriction that's consistent with historical tradition. They did not, I mean, sometimes people like to kind of make all of this sound very cartoonish and say historical tradition, well, we didn't care about domestic abuse 200 years ago, so that's the end of it. That is not the way the Fifth Circuit analyzed it. They actually looked at it more in terms of, okay, we're gonna think about this as a restriction on people who are proven to be violent. We're gonna think of it in terms of what kinds of restrictions were permissible in that area. They really didn't kind of say, look, historical norms about domestic violence have changed and therefore the defendant automatically wins. And I don't think that's really the way it's gonna be argued at the court. I think the case really, it's still in early briefing. The respondent Mr. Rahimi hasn't actually filed his brief yet. So we've only seen what the government has to say here. But I think this case is going to largely come down to understanding what is a good enough historical analog. And in Bruin, the Supreme Court had a lot of discussion to try to help courts think about that. But they said basically that there's at least two really important metrics for deciding whether a historical law is a close enough analog to a modern day law: the how and the why. And if you think about it, it's interesting because it's essentially the means and the end, except, instead, the way I've put it, I argue a lot of these cases is, you still look at the means and the end. It's just, you don't compare them sort of abstractly to whether you think they're good enough. You ask, are these historical means that were used for the same ends historically? So you just have something different you compare the means and the end against, but you are kind of just, looking at the means and the end of the law. And here, I think the principal kind of argument is focused very heavily on the end of, look, this is a law about ensuring that people with a proven propensity for violence should not have firearms. And historically, there are plenty of instances where people, engaged in violence, or if you used firearms for violent ends, you'd face higher restrictions or not be able to have them, what have you. So there's certainly a history, and understandably so, and I don't think most of us resist the proposition that we don't really want firearms in the hands of people who have been proven to use them to commit violent crimes. But you also then have the question of the how, the means, and you have to ask, okay, but how do we go about deciding who fits in that category and what kind of process is necessary to put somebody in that category? And here, one of the critical things that's a little bit different, some of the same issues have arisen in the context of the felon in possession laws, but the debate there becomes a lot more about violent versus nonviolent. Here, I think what makes this provision a little bit different than what you're dealing with there is that it's a civil order. It's a civil restraining order, that there is notice and opportunity to be heard. There's a hearing, there's a finding, but it's not something that comes with the full trappings of criminal law. So it's a little bit different process. And part of the question is, okay, even if you accept the proposition that, yes, you can have restrictions on keeping firearms out of the hands of people who fall into categories determined to be violent, how do we decide who goes there? What kind of process do we need to put them there? And those are questions that have a lot of ramifications, not just for this particular provision of federal law, but for a lot of different provisions that are out there in state and federal law, criminal provisions, but also things like red flag laws, things like, a lot of this has also been litigated in the context of the psychiatric restrictions with people, who it's been 30 years since they once had a psych hold and they've moved on with their life, but nonetheless, it's a permanent encumbrance on Second Amendment rights. So whatever the court says here, will have a lot of implications for all areas, just because we've gotten so little guidance from the court at this point, and there's so many open questions about how to litigate Second Amendment issues. But certainly for kind of a wide swath of provisions that exist out there right now that allow for preventing people, particular people, from being able to carry firearms.
Yeah, we've been wondering ever since Heller, really, how the court would start to think about the Second Amendment as applied to criminal laws and criminal prosecutions. And I think this is the first.
Yeah, they have the Sumrev and the Catano case back,
okay.
But this is the first one that they really are.
So the first time that the criminal case is really the basis. So I'm looking at Sean. I know we want to be cognizant of time here. Rahimi really is the biggest case on the criminal docket. Maybe in the next 5 minutes, Erin and I can mention a few others to look out for and leave a little bit of time for your questions. I'll talk about one other constitutional case on the court's docket. It's called McElrath versus Georgia. It's a double jeopardy case. And you're probably, you'll remember the basic rule that if a jury comes back on a multi-count case with inconsistent verdicts, the acquittals are good, regardless of whether or not they're arguably inconsistent with some of the other counts on which the jury convicted. And so that's kind of a bedrock rule of double jeopardy law. But Georgia's sort of pushing against that rule here. It's a case where an individual was charged with a single incident of killing his adoptive mother, and it was charged with murder, and then a couple of lesser included offenses, felony murder and aggravated assault. His defense was a mental illness insanity defense, and the jury came back and they acquitted him on the murder charge, saying not guilty by reason of insanity, but they convicted him on the lesser charges, saying guilty but mentally ill, which is still a guilty verdict. And on appeal, the Georgia Supreme Court said those verdicts are not only inconsistent, they're repugnant, because you cannot be sane and not sane doing the same act. And so the entire verdict across the board is a nullity and void, and you can retry him on all the charges. And so the question in front of the Supreme Court is whether this repugnancy test is something different from the general inconsistency rule, and thereby you could think of it as an exception or a limit on that double jeopardy principle. And I think the thing that I'm going to be watching in this case, and tied into Rahimi a little bit, is it's a constitutional law case. And last term the court had a case called Samia, which involved the Bruton doctrine of confrontation clause jurisprudence. And the court basically, I would say, read that doctrine extremely narrowly, because at court it was not convinced the Bruton doctrine itself had sufficient history and tradition behind it. And so we're not going to give you an inch more. And I had the same problem myself a few terms ago in a case called Currier versus Virginia, where the collateral estoppel wing of double jeopardy law that's under the Ashby Swenson banner was up in front of the court, and I think I got kind of the same decision. Like, we don't think that's right to begin with, so we're not going to move it an inch. Here, I think there's more history and tradition behind this acquittal rule based on inconsistent verdicts, and so I'm guessing and hoping that the court will, even if you consider this moving it an inch, will be willing to do so. But that's kind of the way I'm going to be watching this case, just to see whether, how it approaches different constitutional rights that were established before the current methodology that seems to be more and more taking hold.
Yeah, and this case has more of a feel of just like a weird exception that a state thinks it can have to what everybody else has always thought was the law. And, so if they can process it that way, it seems likely that it'll be like, we're not actually giving, we're not really giving an inch. We're just saying calling it something else doesn't get you to a different result.
A labeling case.
To me, it's all like the framework through which you think about it. I'll briefly mention the Pulsifer case, which is it's First Step Act case involving a circuit split about the amendments that the First Step Act made to the safety valve provision that allows for reduced sentencing in certain drug crimes. And the safety valve provision has like 5 components, and the first one deals with the defendant not having meeting certain criminal history requirements, and that's the provision that was amended by the First Step Act to basically make it kind of less demanding than it was, and that's the provision that's at issue here. And so what it now says, in order to qualify for the safety valve, the defendant has to not have A, more than 4 criminal history points with some exclusions, B, a prior 3-point offense as determined under the sentencing guidelines, and C, a prior 2-point violent offense as determined under the guidelines. And essentially the question here turns on the meaning of and in connecting all 3 of those things. The defendant says and means you have to have, you only you only don't satisfy this if you don't have all 3 of those things. And the government says, no, as long as you don't satisfy any of the 3, you are not, you're not eligible. I think the defendant here is a pretty powerful argument, textual argument, that essentially boils down to just like, and means and, not or. You would have said or if you meant 3 different things, and particularly when you tie the 5 overarching pieces of the statute together, it's done with and everyone agrees and means and, not or when it comes to that piece. The government conversely, so one, they didn't fall into the trap of actually arguing or. They argued the distributive canon should apply here, so you should read it as saying if you do not have X, do not have X, Y, and do not have Z. So they have enough of a textual argument, but I think where they really end up having their most powerful argument is first, these things kind of fit together. They basically say, look, anyone who's got a 3-point offense and a 2-point offense already is going to satisfy having a 4-point offense, which is the first piece of it, so you'd be like rendering sub A superfluous. And then they also make a powerful argument of like, why would Congress want to make it such that you can have, we don't care how high your criminal history is, as long as you never committed like a 2-point violent offense and you instead committed a bunch of 3-point offenses. So I think they really do have like a pretty powerful, this doesn't make a ton of sense. And it really probably will be one of those cases about like just how textualist is the court really going to be.
In some ways, it's like the inverse of Dubin and some of these other cases where the defendant is being the literalist, and the government is now the one saying, this doesn't make sense, this isn't what Congress would have wanted. So it'll be interesting to see how the court reacts to that. And it's a perfect case for the modern Supreme Court, the meaning of and. I had a case a couple years ago about the meaning of the word so, S-O, and all these cases. So one last case I'll just mention so you're aware of it. It's actually a pair of cases, United States versus Jackson and United States versus Brown. So Jackson Brown, for all of you of a certain age. It's about the Armed Career Criminal Act, and it seems like the court has to have an ACCA case on the docket like every term. So this is the one this term. Remember, the ACCA gives people enhanced sentences if they have 3 prior convictions of either serious violent felonies or serious drug crimes. This is about the serious drug crime prong. And basically the issue is when you look at an old state offense to see whether or not it satisfies the definition of serious drug crime, and you look at the federal list of controlled substances, do you look at the current list of substances now at the time of this federal prosecution and conviction, or do you look at the list of controlled substances maybe 5, 10, 20 years ago when the state conviction occurred? And for those of you that toil in these vineyards, you might know that the schedules change every year. They change regularly, and so that can matter. And so to use the Brown case as an example, hemp was the controlled substance at issue in a prior conviction there, and now hemp is no longer listed on the list of controlled substances. So it's a statutory interpretation question about this temporal thing. And I think maybe if there's anything that rises above just the ACCA consequences of the case, it has to do with how you read cross-references in statutes. So the way the ACCA reads is it's controlled substance as defined by the Controlled Substances Act. And so the government admits that like if ACCA itself had been amended, you'd obviously apply the current version of ACCA, but the government says because ACCA itself hasn't been amended, just the thing it incorporates has been amended over the years. You look backwards to the prior version of the thing that was incorporated. So if you're still with me and you care, and the Sutherland Treatise on Statutory Interpretation is on your desk and one of your favorite bits of reading, this will be a case to watch.
And we care very much because we filed an amicus brief in that case. All right, thank you both. We are now going to give them a couple of cracks at questions. Just a reminder for any press in the room, the Q&A is completely off the record because we like our speakers to be candid with us. So who has a question?
Hi. Thank you for this. I'm going to throw you a question that asks you to look maybe one term ahead, but is another First Step Act question. So as you all might know, the U.S. Sentencing Commission recently put out a revised policy statement on compassionate release under the First Step Act. There is some argument that this is an expanded reading of compassionate release. So I'm wondering if you all see this sort of union of criminal law, administrative law making its way up to the Supreme Court in a couple of years, and under what standard you would evaluate it. Curious for your thoughts on that.
That's a great question. And I don't know, Erin, given her Chevron work, may have things to say as well. But there is this question whether guidance and commentary and even parts of the guidelines themselves would be affected if the court limited or overruled the Chevron doctrine. And so I do think that's a question that could well be headed to the court coming up in recent years. I think it's definitely something to watch. And I don't know whether you've looked at that flavor of Chevron, but
Yeah, I haven't, and I mean it is an interesting question, and I just have this instinct that the court's going to think about the guidelines differently. I think partly because of the way they're promulgated, the way the statutory structure surrounding them, and partly because it's rendered them advisory, so there is like that dynamic of but it is a really, it does, it's one of the areas that's like a little bit trickier to think about what you're going to do with it if you get to a world where you don't really have deference anymore, and how you deal with that on the back end.
Yeah.
There was a case recently where the court had the opportunity to take up acquitted conduct sentencing. They declined it, as they always do. But interestingly, Justice Alito wrote this separate statement, which I bet you guys are familiar with, where he made this originalist case where he was arguing that acquitted conduct sentencing is actually very consistent with the American foundings principles and the Constitution, things we've done for hundreds of years. It was pretty clear that he was trying to get out in front of the originalist argument because he thought a lot of his originalist colleagues might be persuaded by it. I admit I didn't dig into all the footnotes in the Alito statement, but it seemed implausible that acquitted conduct would have been consistent with what we did at the founding. I wonder if you guys have thoughts on this.
So I haven't done like the law review site check on Justice Alito's writing myself either. I'm one of many people who have filed cert petitions on the acquitted conduct issue and had them denied. So in the course of that work, I have dug somewhat into the history of the right to jury trial and think there is a strong historical argument in favor of interpreting the Sixth Amendment to ban the use of acquitted conduct to increase somebody's sentence. But I don't know that there's airtight evidence either way, like it's one of those levels of generality questions. So I think the thing that I would say is I find it really interesting, and another one of these issues to watch, that you now have, I think, 4 votes on the court to say we think this is an issue we ought to take up if the Sentencing Commission or Congress doesn't. And so we're really watching it. And I think you're right, Justice Alito's trying to get ahead of the issue from the prosecution side. And I'll just say, in Apprendi and Blakely and all the other cases involving the modern right to jury trial as it's been interpreted through a historical lens, Justice Alito has tended to be in the dissent in those cases. So I think stay tuned to see what the majority thinks about that. But it's definitely an issue that maybe finally is going to break through at the court if some other actor doesn't step in.
Hey, Jason Pye with Due Process Institute, and building off the question from my friend Ames over here. a lot of my past was spent in conservative and Republican politics, and the mention of the Chevron deference is particularly interesting given its dominance in the administrative state. And I'm curious, from a progressive perspective, what is the progressive view on Chevron given its interplay with the criminal legal system? And I mean, clearly the votes might be there to overturn Chevron, and I'm just wondering, how do you feel about that?
I'm going to have to defer that to you. So I don't purport to speak on behalf of the
I don't necessarily either. I think Erin, I want to hear what Erin has to say, because she really is right there on all these Chevron questions. But I do think, I would just say I don't see it necessarily as a partisan issue. And I think that I have lost cases myself. I've lost environmental cases. I've lost immigration cases where it's like if Chevron wasn't there with a thumb on the scale for the government to do what you might have think of as the non-progressive thing, we might have won those cases. Chevron itself was deference to the Reagan administration on an issue of environmental policy. And so I think, maybe these things shake out certain ways progressive, but I don't think it's an easy issue to label. And I think that it just requires you to think harder about the consequences. So I'd stop there.
No, and I would say kind of from the flip side, as someone who's maybe a little better at representing the, sharing the views of like business communities and conservatives, I think that people come the same way. I mean, it's been hard for groups like the Chamber and such to figure out exactly where, because the reality is you win and you lose some. And so it really is a great issue because it puts it forces you to think about, like, what do you actually think is sort of right about separation of powers and how this should work and and the methodology. And it has to be a little bit divorced from the substance because it just doesn't always shake out, or even necessarily kind of more often than not shake out in one direction or the other. The reality is probably in a Republican administration, like, one side likes Chevron deference, and in a Democratic administration, the other side likes Chevron deference. And so it's not bad for anybody. It's equally good and equally bad for everybody, I think.
Well, the next time there is an opening on the Supreme Court bench, I submit that either one of the lawyers here would be a perfect choice. I hope to see both of them. You are affable. You are genius. You have helped us get through an overeager harpist in the hallway, very aggressive harpist, and as well as a literal false alarm in the building. And so I thank you so much, and help me thank them for their time and talents today.